Fiduciary conflict of interest claims are really common. Conflicts of interest can be a confusingly gray area for fiduciaries, especially when they're also a beneficiary. Trustees, executors, conservators, and power of attorney agents, also called attorneys in fact, often don't know they even have a conflict or have committed any kind of breach of that conflict of interest. It can be hard to recognize what does and doesn't constitute a conflict of interest. Let's talk about this. What is a fiduciary conflict of interest? When what is best for beneficiaries runs counter to what's best for a fiduciary, the fiduciary may have a conflict of interest. If they fail to disclose that conflict or engage in self-dealing, they may be held legally liable and face surcharge, which just means money damages. The golden rule for all fiduciaries is that they must place the interests of the beneficiaries above their own interests at all times, in all matters. Fiduciaries have a legal duty of loyalty, and this duty naturally involves avoiding conflicts of interest. But just because a fiduciary has a conflict of interest doesn't mean they have to relinquish their position, or even that they can't profit from it. They just need to be entirely transparent and proactive in disclosing the conflict and getting approvals from those they serve, or from the court. What is fiduciary self-dealing? Self-dealing goes hand in hand with conflicts of interest. Fiduciary lawsuits are on the rise, so much so that in recent years, California added a legal provision to their statutes prohibiting self-dealing, specifically. A fiduciary has engaged in self-dealing if they've exploited their position for personal gain. It's that simple. For example, a fiduciary can't sell the assets they're managing to themselves at a lower than market price, or charge excessive fees to manage a trust. Self-dealing constitutes a breach of fiduciary duty and can result in money damages being awarded to the plaintiff. And more often than not, the offending fiduciary most likely will be removed. What are some examples of fiduciary conflicts of interest? Fiduciary conflicts of interest abound and take many different forms. Sometimes the fiduciary is not even aware that they're involved in a conflict of interest because they're simply trying to do their job in the most convenient and efficient manner possible. In the context of estate law, trustees, executors, conservators, and power of attorney agents may be accused of conflict of interest when 1. They sell estate assets to themselves, 2. They buy assets from themselves with estate funds, 3. They hire their own company to perform estate services, 4. They charge excessive fees, 5. They receive indirect payments or kickbacks from other parties that are involved in estate management issues, 6. They sell property or real estate that co-beneficiaries want to retain, sometimes because they're the real estate agent. 7. They refuse to sell property or real estate that co-beneficiaries want to sell. 8. They make loans or gifts to themselves from the trust estate. 9. They use a third party or separate account to divert funds to themselves. It's also embezzlement. 10. They make investment decisions that benefit themselves, but not the other beneficiaries. Does a fiduciary have to resign if they have a conflict of interest? No, not unless they choose to or are ordered to do so by the courts. The fact is that most fiduciaries do have conflicts of interest, especially when they're also beneficiaries. But just because a conflict exists does not mean that a fiduciary can't serve in their role. They simply need to be cognizant of that conflict, and they need to be transparent with the trust beneficiaries to ensure that they're not favoring themselves over the other beneficiaries. A good trust litigation attorney can help you navigate those waters. Oftentimes, if a fiduciary is open and honest about the fact that they stand to profit personally from a transaction, the beneficiaries may consent with it as long as it's also good for the trust and for them. The key to avoiding self-dealing claims is clear communication and thorough disclosure. All fiduciaries should consult a trust lawyer if they think they might have a conflict of interest, or maybe they were accused of having one. An attorney can help draft disclosure documents and otherwise protect a fiduciary from what are otherwise entirely avoidable lawsuits and potential liability. Can I be sued even if I disclosed a conflict of interest? In certain cases, sure. Many fiduciaries think informal verbal disclosure of a conflict of interest is sufficient to protect them from a lawsuit, but disclosures must be made in a timely, formal manner, and they should be written so you have a record of it. And most importantly, the beneficiary should sign off on it. That way it proves that even though there was a conflict, there's no dispute. If the beneficiaries won't sign off, the fiduciary can attempt to effectively go over the head of those beneficiaries by using a notice of proposed action, which acts as an authorization if the beneficiaries fail to object, or the fiduciary can go to probate court and seek an order on a petition for instructions. But they can still be sued later on in a self-dealing transaction, had unforeseen negative consequences the trustee did not reveal, or if the fiduciary had special knowledge that, again, they failed to reveal to the other beneficiaries. In other words, consent must be always fully informed consent. Can a fiduciary profit personally if it's also good for the beneficiaries? Yes, but not excessively so. And even then, a fiduciary will be best served to get beneficiary consent. In many cases, a fiduciary doesn't realize they've engaged in a self-dealing transaction because it was also good for the other beneficiaries. And if this is truly the case, legal issues usually don't arise in the first place. But when a fiduciary benefits personally from any action they take, the impartiality of their judgment is going to be called into question. And the question then becomes, would a prudent person who didn't stand to profit in the same way have done the same thing? If not, the fiduciary likely will face civil liability and potentially removal from their position. This is why full disclosure and consent is so important. It's always best to err on the side of caution. How does a fiduciary avoid conflicts of interest if they're also a beneficiary? Many fiduciaries, like trustees, executors, conservators, and power of attorney holders, are also heirs and beneficiaries of the assets they're managing. This can make things far more complicated, at least in terms of avoiding self-dealing or conflict of interest claims. If a fiduciary is also a beneficiary, they need to be extra careful not to ingratiate themselves at the expense of co-beneficiaries. They must not be perceived as abusing their authority to profit disproportionately from their position. It's absolutely vital for fiduciary beneficiaries to make sure they're on the same page as co-beneficiaries, and to the extent possible, to get this in writing prior to engaging in any of those transactions. Some fiduciaries even opt out of their role if they're afraid of facing a potential lawsuit or just don't want to deal with the family tension and infighting. You should always consult with a good estate litigation attorney before you decide whether to serve as trustee. They can help you navigate the conflicts of interest and help shield you from liability. Have questions about any of this? Give us a call, shoot us an email. The consultation's always free. Thanks for watching.